If you are planning on attending any of the more than 1,800 No King's Day protests that are scheduled for Saturday, June 14th, you need to listen to this. And honestly, like, this advice applies anytime you are going to a protest or anytime you think you might be interfacing with law enforcement. Turn the biometrics off on your phone. Turn your Face ID off, turn your thumbprint off. Make sure that you can only open your phone by entering the code. One of the most watched videos I have on my YouTube is where I am stitching my mutual hawk, where he made a really short video that was like, turn your Face ID off on your phone. And I said, oh yeah, you may not know the reason that you need to do that is because the courts have decided that the cops can forcefully get into your phone with your thumbprint or your face. They can take your thumb and put it on the phone and open your phone without your permission, or they can hold it up in front of your face, open your phone without your permission. But that was like a 45-second long video, and I didn't explain it very well. So I'm going to take a second and do that here because I think it's really important that you understand that you turn off any of your biometrics on your phone. Make sure you can only open your phone with the code that you punch in yourself, because the police cannot compel you to enter a code, but they can compel you to put your thumbprint right there on the screen or to put your face in front of the camera. And also, you know, it would not be a bad idea to leave your phone at home altogether. If you can in any way leave your phone at home, please do that. I know it's not possible for everybody. Or if you can get a burner phone, do that. And also, if you have to bring your phone, put it on airplane mode. I do understand it's really important for us to be documenting what's happening at these protests. So far in LA, there's been lots of recordings of the cops and ICE doing pretty shady shit. Anytime law enforcement rolls up, somebody in your group needs to be in charge of documenting what is going to happen. And that when you do that, it's really important that as you're documenting, you are basically live streaming it, or you're uploading it to the cloud as you are recording in case something happens to your phone, in case they take your phone. Make sure that that is being sent off-site as you are filming. So again, I understand why we need phones at protests, and I understand why not everybody has the opportunity to buy a burner phone. So if you have to take your own phone, you don't want the cops to be able to get into it without a warrant. And just be careful if you're searching this up on the internet, because I noticed the American Bar Association has really outdated advice. They have an article up from 2019 that basically says the cops cannot use your iris or your fingerprint or your face to open your phone. Yeah, the law has changed since then. In April 2024, a federal court ruled that police officers actually can make you unlock your phone with your face or your iris or your thumbprint. They can even forcibly put your thumb on your phone. In case you enjoy reading case law as much as my 20-year-old does, the case was decided in the Ninth Circuit Court of Appeals on April 17th, 2024, and it is United States versus Jeremy Payne, P-A-Y-N-E. So basically, Jeremy Payne was pulled over in California in 2021 because officers said that his window tinting in his car was too dark. Various states have various regulations about how dark your window tinting can be, and I guess they felt that Jeremy's was too dark for California. When officers asked him, Jeremy Payne admitted that he was on parole. Officers found his cell phone in the car and then forcibly pressed his thumb to the phone as he sat handcuffed in order to open it and see what was on it. They didn't have a search warrant that had probable cause because they pulled him over for windows being too dark when he was on parole. I guess that gives them cause to do that. By the way, in the arrest filing, the officer documented that Payne, quote, reluctantly unlocked the cell phone. Payne vigorously disputed this, and the government later admitted in court that actually, quote, the defendant's thumbprint was compelled. So, you know, to say the very least, the officer's description of events was embellished. So while Payne is handcuffed, they force his thumb onto the phone, they open it, they scroll through his camera roll, and they find a video that was taken the same day that appeared to be incriminating. They then used the phone's map to figure out a home address that he had been to, and they drove there, and then they used his keys to enter and search that residence. Inside, they found pills, so Payne ended up being indicted on possession with intent to distribute for fentanyl and cocaine. His attorneys filed a motion to suppress. Right, the whole cascade of events, if they were not able to open his phone without his permission, forcibly put his thumb to the phone, none of the rest of that would have happened. There would be no case. His lawyers said that officers compelled a testimonial communication, which would be a violation of the Fourth Amendment's protection against unreasonable search and seizure and the Fifth Amendment's guarantee against self-incrimination. The district court denied the motion to suppress, and Payne ended up pleading guilty. He was sentenced to 12 years in prison. Interestingly enough, he got 12 years in prison for possession with an intent to distribute, but he was out on parole after having only served 3 years for assault with a deadly weapon. We could get into, I should have my kid come talk about this because she just did a research paper on this about drug policy in the US and how our drug policy, especially sentencing laws, they don't work. The war on drugs is an utter failure. But okay, anyway. So obviously Payne appealed the denial of the motion to suppress, right? Kicked it up to the next court. And the Ninth Circuit Court of Appeals came back against Payne. Once again, he lost. So searches that are, quote, incident to arrest are considered an accepted part of the Fourth Amendment. Right? No unreasonable search and seizure, but if you're in the process of being arrested, there are certain reasonable searches that are allowed under that. And also, Payne was out on parole, and we know that parolees have, quote, a significantly diminished expectation of privacy. However, it's important to note here that the conditions of his parole did not require him to give up biometric identifiers. That is not something that he agreed to. But the Ninth Circuit felt that that was insufficient to get the whole thing thrown out. So this is the part that I find extremely interesting, which is I get why under the Fourth Amendment, they're like, no, we can make you use your thumb. There's an expectation that your phone could be searched that way, but they can't compel you to speak, right? The Fifth Amendment protects you from self-incrimination, so they can't force you to tell them what the code is to get into your phone. But is being compelled to use your thumbprint or your face to unlock your phone, is that self-incrimination? They are using a part of your body against your express consent to look at your personal information, which could be incriminating as it was in Payne's case. The court said, no, it's fine for them to do that because it required no cognitive exertion. The court said, no, this is in the same category as having your blood drawn or your fingerprints taken when you are booked into custody. Which I think is interesting because the Supreme Court ruled in 2016 that you cannot be compelled to give a sample of your blood if you've not been arrested. If you're just a suspect, they cannot compel you to give a sample of your blood without a warrant. I find this particularly chilling because your phone gives them access to all kinds of information about you, right? If they can use your thumbprint or your face without your permission, and you have those biometrics turned on in your phone, think about all the apps that they can get into with just your face. Your banking app, your private messaging, photographs, your travel history, all your call and text logs, all of this information that otherwise would require them to have a warrant. No, they're allowed to get it if they can get access to your thumbprint or your face. This ruling from the Ninth Court in 2024 allows them to circumvent having to get a warrant. So I hope that provides some context about why it's so important to turn the biometrics off on your phone if you think for any reason you might be interfacing with law enforcement. I turned the biometrics off on my phone on April 5th and I have not turned them back on. Yeah, it's a little bit inconvenient. I have to enter the code every time I want to access a, secure app or I want to get into my phone. That is a small price to pay. I understand why you might have to bring your phone to a protest, but if you have to, please, 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 please turn your biometrics off.